right, we'll start in 1 minute. Give people a chance to sign in. Okay. All right, I think we have just about everyone. Everyone hear me okay? Just give me a thumbs up. Okay, very good. Please sign into the attendance on iClicker. It should be running now, if you have a minute. A few people still trickling in. If you could just name yourself last name, comma, first, I would be grateful, because that makes my recitation a lot easier, because you'll sort it alphabetically. I can go right down the roll. So you can just rename yourself. Rename yourself last name, comma, first. I would appreciate it. Okay. Let me give you an update on the grading situation, which is that we have no update. We had a faculty meeting on Friday that lasted nearly 2 hours, and we didn't make a decision yet. This is an issue in which a lot of people, I think, have very compelling thoughts, and hopefully we'll get a resolution at some point this week. For your purposes, it really shouldn't matter what we pick. My goal is to give you the exact same exam I've given you whether you're in the building or not. And I'm going to grade you exactly as I would otherwise. I will give you your grade, whatever you get in A, B, C, or D. I'll tell you what your grade is. It doesn't really matter what goes in your transcript. That's beyond my control. But at least from my perspective, you'll know what you get. So I am not changing anything. I'm going to do it exactly as I want to. I've told you in the past that my exam's open book, your notes won't help. I mean that. In fact, I don't think you can cheat on this exam. If you try, I'll know very quickly because it's all essay. This doesn't make a difference for me. For other classes that are multiple choice, that are closed book exams, it will make a difference. But for my class, I don't care. It makes absolutely no difference. I will handle it exactly what otherwise. I'll grade it exactly the same. I will give you your scores, A, B, C, or D, whatever it is. Whatever. It's beyond my control. We'll decide what we decide. Any questions or any comments on this, you can raise your hand and I'd be happy to give you the screen. Who is David 9 Floor? Who is that? Oh, I see David 9 Floor. Okay, that's you. Okay. Yeah, that's not your name. Moises asked if I still plan on canceling class next week. Yeah, let me mention that. Thank you, Moises. Next week is the Jewish holiday of Passover. If anyone's celebrating, have a lovely Passover. The holiday actually begins on a Wednesday evening. So I had planned to cancel class Tuesday because I thought I'd be going home to New York, which I'm not. So we'll have class on Tuesday the 7th, but we will not have class on Thursday the 9th. So in other words, we don't need to cancel class on Tuesday because I'm not getting on a plane, so I'll be here. But we will not have class on Thursday the 9th. I'll send an email around with the revised syllabus later, so everyone has the correct schedule. And if for whatever reason you can't make it on Tuesday, just let me know. Okay. Yeah, I would much rather be home for Passover for New York. It's the first time I'm not home for Passover since I think law school. It's been a very long time, so it sucks, but we'll make do. Any other questions? Things in your mind? No? All right, let's do a poll question to start. See if I can do this quickly. All right, I think I got this right. All right, so here's your question. And you should all see the screen share on your clicker. The elective share is available in community, property states. The elective share is available in community property states. True or false? I'll give you another 20 seconds or so to put your answers in. Okay, another 10 seconds. All right, I see all of your eager faces. All right, let's get started. Who's up next? Who's the next person?
That would be me.
Is that Tony?
Yes, sir.
Okay, Tony. So, Tony, help me out here. Remind us, what is an elective share? What does that phrase mean?
So in the elective share, it was a way for, like, if you tried to keep your spouse from getting any of the assets when you died or something, they could take that elective share.
Right. So
it's normally a half or a third.
Yeah, exactly. So, Tony, let's just say, I decide to write my wife out of my will and I leave her 0. What can my wife do upon my death?
If she takes the elective share in the state where she can, then she gets that third or half, whatever it is for that state.
That's right. Okay, thanks so much.
That'd be the only way she can get something.
Yeah, and thanks so much, Tony. Right, so the purpose of the elective share is to help out the surviving spouse who gets screwed, right? The surviving spouse who gets zip, who gets nothing in the will. Now, if the husband leaves the wife everything, she doesn't need to elect. That is, she doesn't need to choose the elective share. It's sort of like a plan B, if you will. Like if you get in trouble, you elect for this share. But what exactly does the wife get half of? Tony, who's next? Is that Haley is next, I think?
Yeah.
Haley, what does the wife get half of? Let's just be very precise here.
The shared interests.
What do we call that? You're right, but what half of what?
The property.
More precise, what kind of property?
Community property.
Don't say community property.
Okay.
Right? Well, what kind? And I'll ask you the question: is the elective share available in a state like Texas, in a community property jurisdiction?
No, because they already get a share of that property.
Okay, so you're right. So the answer to this question is false. 85% of you got it right. Very good. So Haley, there's no community property in New York, right? That phrase doesn't exist. So let me ask you the question again, Haley. The wife gets half of what?
The marital property.
Yes, that's exactly right. The key phrase, and I want to make sure you get this in your notes clearly, is that with the forced elective share, the wife can elect for half of whatever the marital property is. Right? The wife can get half. That might not be everything. Perhaps the husband has property that he acquired before marriage, right? Maybe the husband has some inheritances. Maybe the husband received gifts. Those are not considered marital property. But the wife can elect for half of whatever the marital property is. So let's just say, he has $1 million that he had before the marriage, and there's $1 million for marital property. The wife would get half of the $1 million acquired during the marriage, half of the marital property. Make sure you don't include things like inheritances, right? Or things like gifts or property beforehand. That's not marital property. The wife can't touch it, even with the elective share. Okay? Makes sense, everyone? Now, Haley gave me the right answer a minute ago, right? She said that the elective share is not available in a state like Texas, right? In a community property state. Doug, you here? I'm sorry. I skipped Troy. Troy, you here?
Yes. Can you hear me?
Oh, no, Doug wasn't. Oh, yeah, you're next, Troy. So I think I skipped you before. I'm sorry. So Troy, why is the elective share not really necessary in Texas, in a community property state? Why do we not need to have the elective share in Texas?
I missed last class, but what I saw in the video is that is it automatic?
Well, what do you mean? What's automatic?
So that you don't need the elective share because don't you elect into the marital property? Well, you can elect to have half of the marital property, but in Texas, if you're divorced, then you automatically get half of the marital property.
Well, we're not talking about divorce. We're talking about death. Yeah, it's always death or divorce, right? So in Texas, right, if you have a husband and wife and the husband dies, can the husband screw the wife and leave her nothing?
No.
Why not?
Because because there's community property in the marriage.
That's right. The wife is entitled to half. Thank you, Troy. The wife is entitled to half of the community property, regardless of what's in the will. Right. So effectively, in Texas, you don't have an elective share. It's not called that. But by operation of law, by operation of the community property statute, the wife can basically take half of the marital property, and perhaps a little bit more. We'll discuss later. But it's basically impossible to write the wife out of the will in Texas. You can't do it. You can try. It just won't have much effect because the wife will still get stuff. Okay. All right. Everyone with me so far? Any questions? Raise your hand. No? Okay. So let me review a little bit from last class. Community property regimes exist in a handful of states, mostly in the Southwest. Arizona, California, Louisiana, Nevada, New Mexico, Texas. For reasons I don't know, Idaho, Washington State, Wisconsin, and apparently Alaska, not really in the Southwest. But these are states that have influence from the French and the Spanish system of government. This was called the continental approach, right? On the European continent, you had community property. In England, you had what was called the common law property, right? The common law property regime. And that's what exists in most states in America, New York, and elsewhere. I want to just make sure you keep your terminology straight. When I say common law marital property, I'm referring to the English system, where there can be separate interests, right? I'm not saying common law versus modern, and people often get those terms confused. I mean common law is in the English system, what's in New York, okay? And when I say community, I'm talking about the system in Texas and California and some other states. All right, make sense, everyone? Yeah? All right, is someone raising a hand? Yes, anyone raising their hand? No, okay, I think someone stretching. All right, the next point I want to stress is that issues of marital property only matter at two times: death and divorce. During the life when the husband and wife are married, none of this really matters. You don't have divisions of assets while a couple's married. You only deal with division of assets at death or divorce. Death can be complicated because you might have a will. And the will says all the property goes to a child, for example. But by operation of law, the surviving spouse can basically nullify that will. Divorce is trickier because you might have a prenuptial agreement or some other agreement that says we agree to treat this property as separate. You may also have situations where a couple migrates. They move from New York to Texas or Texas to New York. Property, land, doesn't move. If I own Blackacre in New York, it doesn't move. But let's say I own a piece of personal property like a horse. A horse can move. So the rules get very messy when you move from state to state. Okay. Now, another review. What is marital property? Most pieces of property acquired during marriage are marital property. There's some exceptions, right? What about property that you had before the marriage? That doesn't count. That's not marital property. What about gifts or inheritances? Generally not marital property. Okay? You can also reach what's called a prenuptial agreement. Pre means before. Nuptial means your wedding vows, before the wedding vows, which says that certain types of income will be treated separate. But you have to be very careful of how you manage that. Okay? All right, so now let's move on to the new stuff. In a community property state, whatever income one spouse earns is considered community property. It doesn't matter in Texas if a husband puts his money in his, in a personal bank account the wife doesn't have access to. The presumption is any income earned is community property. If the husband earns $1,000 a month, half of that belongs to the wife. If a husband buys 10 shares of stock, even in his own name, the stock is marital property and the wife owns half. And the reason why we have this system is that we say the husband and wife contribute equally to the success of the marriage. Okay. Now, there are some wrinkles, right? Let's say a person owns Blackacre before the marriage, and Blackacre is a rental property. What about the rental income? In Texas, the income from the rental property is community property. So even though Blackacre might be, before the marriage, might be a separate property, the income is considered rent, and that is community property. In California and other states, rental income is different. But at least in Texas, rental income does count as community property. Stuart asks, what about dividends gains on stock purchased before marriage? I think at least in Texas, the dividends may actually be considered community property. I see Cameron has his hands up. Yes, sir.
I guess it was a similar question, like a retirement fund where you already accrued so much, but you continuously added to it as you were married. Like all the previous funds are now.
Thanks, Cameron. The issue of retirement funds are complicated. Let me answer this a couple different ways. There's something called a pension, right? Let's say you work for a government employer, the city, and the government says for every year that you work, you get X dollars towards a pension, and if you retire after say 30 years, you get a certain amount based on your service. Generally, if let's say you had a single wife married for the entirety of that 30-year period, the wife is entitled to a share of that pension. But let's say that you're married to one person for 15 years and another woman to 15 years, right? Just right back to back. In that case, they would each get a quarter, right? They would take the half and they would split it. Let's say you have 3 spouses, they each get a third. So effectively, with pensions, it's divvied up based on how many years the spouse is with the working employee, which seems kind of messy, I know, but that's how it works. Retirement accounts are a little bit different. Let's say a person contributes $100 a month to a retirement account. The spouse could actually seek half of the contributions to that retirement account if there's a divorce. Generally, and see here, Nancy, I'll get you in a minute. Generally, when you have a divorce and you have a settlement agreement, you figure out how to divide retirement accounts. That's often a very contentious point because couples often plan for retirement jointly. So it's very messy. I don't want to give you solid answers, but the pension one's extremely difficult because it's based on years of service. And then you have to divvy up how many years you're married during that time. Yes, Nancy, I see your hand.
Okay, so with everything going on, I just last week elected to get a distribution from a defined benefits plan from a former employer. And in the paperwork that I filled out, there was an additional section for if you were married. I wasn't married at the time that I had worked for this employer,
right?
But I still was required to get, if I had been married if I was married at the time, I still was required to get the written consent of a spouse to get my distribution. And I don't fully understand why I would have to have my spouse's permission if this was a pension that I got while I was not married. Is it because of how it, accrues interest or?
Right. So Nancy, let me answer your question. Also, I see Michael's question as well. Let's say when you started the retirement plan, you were not married. Let's say you got married in the middle and then you were unmarried at some point later. The periods for which you were married, your spouse may have a claim to any sort of distribution. Yeah. In other words, Nancy, it would be, I think, almost illegal, not illegal, but it would be improper for your employer to just write a check to Nancy without checking if there's someone else that might have a cut. That makes sense? Well, this happens not only with divine retirement plans, but also life insurance policies. If you are signing up for a life insurance policy, they're going to ask you, are you married? Right? And if you get married, you have to tell them because they can't write the full check to your heirs precisely because your spouse may get a cut of it. Stuart, I see your hands up.
Yes, I was wondering about the retirement accounts because accounts like Roth IRAs or traditional IRAs, they're incentivized to keep them in the account as long as you can. So I think age 65.
Yep.
So how does that work with the divorce? Is
yep.
They're not going to get the money until then, or are they going to be penalized?
Oh, my friend, yeah. So you may not know this because you're all young, but if you withdraw from a retirement account early, there are penalties, right? If you withdraw before you reach 65, there are penalties. And generally, if you have a divorce judgment, it's not a good idea to withdraw early. So what you have to end up doing is taking whatever money the wife is owed from another source and paying it. That is, when I say it's complicated, usually leave the retirement plan in place, and then the one spouse has to give money from another source to compensate the other spouse. So in other words, the spouses get whatever they're due, but you do it without breaking apart the retirement account. Now, let's say there are no other assets, it's only retirement account. You may have to withdraw early and pay the penalties.
You're going to pay the penalties and lose that compounding interest?
And you lose the compounding interest. Nancy just said she has to pay a 20% tax on the disbursement. Yeah, when you withdraw early. But this isn't just retirement plans, my friends. Let's say that you have a division of assets and the only assets the house. You may have to sell the house to pay off the division of assets, right? It's the only asset that's left. Cassidy asks, does that rule apply to both term life insurance and whole life? Like a financial advisor now. I think so. I think any life insurance policy, whatever it pays out, the surviving spouse has a cut to. Being in Texas has some pros and cons, depending on a look at it. This is a complicating factor. All right. Yeah, 20% when you withdraw early, and there are other penalties. Yes, Jayla, I see your hand.
Okay. Can you hear me?
Loud and clear.
Great. So I guess I'm just trying to process what you said about answering Stuart's question about how it would work with the retirement, about possibly paying your former spouse from another account without having to withdraw it from there.
Yeah.
So let's just say you had, I don't know, $40,000 in your account or whatever, and you had to pay your spouse. Your spouse is entitled to $10,000 of that. So to avoid having to pull $10,000 out of that account, you would try to find the $10,000 elsewhere.
Let's say you had an account from before marriage, right? And that's not community property. You would then take $10,000 from that, give it to the wife to avoid having to pay penalties.
Oh, okay.
Or let's say maybe you had some property you owned that was before the marriage, maybe an inheritance, right? You could just pay it from an inheritance, some other thing that's not marital property to avoid the penalty. Make sense? Yeah. It's messy. It sucks. Usually when you go through, I mean, I have a few people on this list who have personal experience, but when you go through divorces, you're not acting in a financially prudent manner. You often have to pay penalties and other types of fees that gut your investments. Yeah, there's another way of saying it. Chris asks, why don't community property states recognize tenancy by the entirety? That's not exactly right. They may have a tenancy by the entirety. Texas kind of does. But the community property laws change things, and that's what we're talking about today. We're talking about the joint tenancies in Texas. Chance asks, if a wedding ring is given as a gift, can the value of that be considered non-marital property? Generally, an engagement ring, I think, is before the marriage. The wedding ring probably is a marital property. So there's actually entire bodies of law based on wedding rings and getting them back. It used to be the law that if a spouse broke up the engagement, the other spouse can try to reclaim the ring. It was called the heart bomb law to make your heart feel better. You would reclaim the ring. Those things are not enforceable as much anymore. Some states still have them, but they're quite rare. I always get a lot of questions in this part of the class. People are like, "Oh man, I gotta get a prenup, right?" Hala, we on prenup, right? Yeah. Kanye said it best. All right, let's move on. I can't hear you laughing, Beckham. Let's assume you're laughing. All right, the next topic I want to discuss is commingling. Commingling, right? Oh, I spelled that wrong. Commingling. No, I got that right. Commingling. What is commingling? This is a word you'll need to know. Commingling is basically mixing, right? Let's say that you have a bank account with your separate property, right? There's a bank account you had before you were married. And then you decide to deposit your earnings in it during marriage. That is, you're mixing, you're mingling marital property with premarital property, right? You're mixing it together. When you commingle, right, the presumption is that the entire account becomes marital property. Right? Even if you had all this money from before you were married and you just deposit your paycheck in there every week, the presumption is this is now all marital property. It's all community. You have to have very strong evidence to overcome that. Right? For example, if the husband and wife have a written agreement, they can abide by it, saying, no, this is going to be separate, this is a community. But you have to have a very stringent arrangement. It can't be oral. It has to be in writing. Okay? Any questions on that? Okay, there's another word that you'll see is called transmute. Transmute, think of like transubstantiation, right? If you want to have a similar word, it means convert. If the husband and wife agree in writing, they can convert community property to separate property. Or if the husband and wife have written agreement, they can convert separate property to community property, right? So for example, let's say during a divorce, the husband says, okay, I will make my retirement account mine, right? You basically transmute it to be solely individual. And there might be a price to pay for doing that. But the concept of transmuting or transmutation allows flexibility, but it's by consent. There's no obligation. They have to consent to change the way property is structured.
So does that one need to be in writing?
Yeah. Okay. All right. Everyone okay with that? Now, one more note on the word commingling. You'll learn this phrase in professional responsibility. Okay? When you have a law firm, all of you will one day hopefully, and you get money from your client, your client gives you what's called a retainer, right? I give you $10,000 up front, and every time I work an hour, I sort of just deduct from that. When the client gives you money for a retainer, you can't put it in your personal checking account. That is a no-no. What you actually have to do is create a separate account for each client. It's true, banks do this. For every client you have, you create a separate trust account, and you put the money in that trust account. And then as you work, you can debit from that account. The easiest way to get disbarred, right? The easiest way to lose your law license is to commingle, is to mix your personal funds in the same account as the client's funds. You get in trouble for that. It's very easy. You'll lose your license. You cannot keep your personal money in the same place. Okay? The Boom, I think that's the book, says that transmutation doesn't always have to be in writing, just usually. My recommendation is you put in writing. Oral statements like this are very hard to prove. So perhaps, but my recommendation is put in writing. Okay? Any questions on commingling or transmutation? No? All right. The next topic I'm going to talk about is creditors. A huge element. I'm sorry I'm lecturing. I'll start calling people in a minute, but there's some background stuff I want to get across. A huge element of marital property concerns creditors, right? That is, if I'm a bank, whose property can I go after? Okay, so the easy example, if a husband and wife both sign a mortgage, right? If a husband and wife both sign a mortgage, the bank can go after their community property and then their separate property. Right? I'm sorry, I flipped it around. The bank would go after a separate property first, and they go after community property second. The idea is if they're both signed on the mortgage, the creditor can go after all their stuff, but they try to do it first, separate property, and then community property later. It's a little bit easier. Okay, but that's if both spouses have signed the mortgage. Let's say only one spouse signs the mortgage, right? At that point, the creditor is limited. The creditor cannot go after the other spouse's personal property, right? In fact, he may not even be able to go after the community property. So the rule is if you are a bank or some sort of lending institution, you require both signatures, right? You're not going to give a mortgage to only one spouse. That would be very stupid because then you can't collect the same. You need both of their signatures. Okay. Chance asks, is debt considered property? I'm not sure what you mean. Is debt considered property? Are you asking, can you divide debt? Is that what you're asking? Can you?
Basically, it's if a husband is, in theory, if he makes money, it's now community property. But if he takes out debt, as he say, he's getting ready, something bad's about to happen, and he goes, all right, well, I'm gonna help everybody out. I'm just gonna go to every bank, open up a bunch of credit cards, buy a bunch of stuff, and then I get corroded or something like that. Obviously they can still go after the husband's separate property, but because you would look at earnings as community property, would you look at debt as also community property?
And your shirt is very very poorly tasted.
That was it.
Yeah, I'll let it go. So the short answer is if one spouse accumulates debt, right? If one spouse does accumulate debt, it can be something that burns the other spouse as well. But as a general matter, creditors could only reach the community property. They couldn't reach the separate property. But it's harder because if the other spouse didn't consent. So in other words, let me put it this way. In a state like Texas, it's harder to collect when you have a situation like Chance described because there will be more community property. But you can still do it, just it's more complicated. All right. Thank you. All right. The next topic I want to discuss is what equitable divorce means. In Texas, the law says that divorces have to be, quote, just and right. Just and right. Okay? What exactly does that mean? It has to be equitable. right? It doesn't mean a 50-50 split. Courts can consider different factors when they divvy up property. Maybe there was fault in the breakup of the marriage, infidelity, usually. There might be unequal earning potential. Maybe one spouse has more earning potential than the other one. Maybe a spouse has health conditions. Maybe custody of children factors into it. What are their educations? What are their future employabilities? There are a lot of factors, but I don't want to pretend for a minute that this is easy to figure out. Family judges have a lot of discretion. They have discretion in awarding custody. They have discretion in dividing up assets. They have discretion, and the courts of appeals generally don't disturb those findings. So whatever the trial judge finds is probably the end of the road in most cases. Okay. Questions so far? I'll move on to the actual substantive stuff. I want to give you that background first, so you get some background. Any questions so far?
Go ahead.
I'm sorry. Who's first? Is that Jayla? Go ahead. I think you're first.
No, it was Anthony. Go ahead, Anthony.
I just had wanted some clarification. When you were talking about creditors, if both spouses sign the mortgage, then they go after the separate property first and then community property?
That's the preference, right? If they both sign it, you try to go after the separate first, then you go after the community.
And what I missed the part when you said if only one spouse signed it, what would they go after first?
Well, if one spouse signed it, you would first try going after the separate property, right? The husband's separate property. But there are some cases where you may be able to go after the community property as well. But that gets very messy because you're basically taking the husband's share in the community property. So it's hard to collect on that.
Okay.
So in other words, Anthony, let me answer your question this way. A collector has a much tougher time in Texas than they would in New York. If I put it that way. And Anthony, what's your background? I don't know what your background is. What is that?
Oh, it's from The Office.
Oh, that's what I thought it was. Okay, very, very good. Yeah. And I see also Cassidy asks, if you make it in front of a judge during divorce, will the judge actually be acting as a chancellor in a court of equity? It's a good question. They're not called chancellors as far as I know in Texas, but they're basically acting as if they were a chancellor. All right, GLA, go ahead, please.
Yes. So for purposes of the exam, since we are in Texas, are we going to primarily be focused? How do I best ask this question? Are we primarily going to be focusing, if we have a question about marital assets and death or divorce, would we be focused here in Texas, or is it open to being anywhere?
I will tell you what state you're in. And what I'll usually do, if you look at my old exams, they'll say a couple moved from New York to Texas, or a couple moved from New York to California, or a couple moved from Texas to Ohio, right? It goes both ways. And you'll have to figure out the migrating couple problem. So the short answer is both.
Okay, thank you.
But always pay close attention to what jurisdiction I tell you you're in. Depending what state I tell you you're in, the laws will be very different. Okay. All right, questions? Awesome background, retweet. Okay, nothing there I have to address. It depends where Nicole asked, it depends where they end up. It depends where they start and where they end up. But also, pieces of property don't move. Land can't move. So sometimes the law of the site of the property dictates the answer. So it's not only where they end up, it's where the property they acquired remains. We'll get to that today. Oh, I see a hand up. That's Jill, is your hand again?
But you can ignore me because I think we're gonna get to it later on in the class because it was referencing something more specifically in the reading, but I don't want to jump ahead.
All right. Well, if I don't get to your point, just remind me later. Is that okay?
Yes.
Okay. Very good. Thank you, Sheila. All right. So let's start today. The hardest part of today's class is understanding how a joint tenancy works in Texas. Joint tenancy, you think you know it, but it's different here. Right? So who's next? Chris, are you next?
Yes. Yes.
So Chris, just remind us, what is a joint tenancy as we study the phrase, Chris, let me ask you a question. When you have a joint tenancy, how do you describe the interest that the two parties have? What's that phrase we used?
Joint tenancy in fee simple?
No. How do you let's just say separate but
equal?
No.
I can't remember.
Wrong class. Separate but I apologize. I'm back.
Okay.
All right. Thanks. Thank you for that, Chris. With a joint tenancy, the two parties have a separate but undivided interest. Okay, Dylan, you here?
I'm here.
So Dylan, let's just say in Texas you have a husband and wife, and they decide to create a joint tenancy. Is it possible for a husband and wife to have separate but undivided interests?
No.
No, why not? Why is it not possible in Texas for a husband and wife to have a separate but undivided interest?
Because in a community property state, they aren't allowed to convey their interests without the other.
Can you have husband and wife having separate interests?
Can you repeat that?
In Texas, can a husband and wife have separate interests in Blackacre?
Not necessarily. It says that they each have undivided 1/2 shares.
Right, but are they separate interests that can be alienated separately?
No.
Okay. All right, so here's the rub. In Texas, a husband and wife cannot have separate interests. Right? A husband and wife can create a joint tenancy, but it operates differently. Okay? I'm going to give you a phrase, right, that I use to help make sense of things. I'm sorry, let me say this again. In Texas, I call the joint tenancy a quasi joint tenancy. I meant to send to everyone. A quasi joint tenancy. Why do I call it a quasi joint tenancy? Because it doesn't really act like a joint tenancy. It's a little bit different. So in Texas, the rules for joint tenancies are different than they are in New York. When you put this in your notes, you can put the word quasi there if you want. You won't see that in any books. That's the word that I use. But it helps me distinguish a joint tenancy in New York from a joint tenancy in Texas. Okay? So how does a quasi joint tenancy work? Well, Dylan mentioned one of them a moment ago. With a quasi-joint tenancy, one spouse cannot convey his interest alone. Right? With a regular joint tenancy, one party can convey his interest in Blackacre. You're allowed to do that. But with the quasi-joint tenancy in Texas, a spouse acting alone cannot convey his interest in Blackacre. Both have to consent to sell Blackacre as a whole, or both can consent to partition Blackacre. One spouse cannot unilaterally convey Blackacre. Okay? In that regard, the joint tenancy resembles the tenancy by the entirety, right? Remember the tenancy by the entirety where both spouses have to turn the key, right? Both spouses have to sell Blackacre. It operates in similar fashion. In Texas with a joint tenancy, both spouses have to consent to sell Blackacre, right? So you ask, Josh, why don't we have a tenancy by the entirety in Texas? Well, you kind of do, right? The joint tenancy operates in a very similar fashion because both spouses have to consent to the sale. Okay, so everyone get that the first defining feature of the quasi-joint tenancy is that both spouses have to consent to convey the property. Everyone get that? Okay. Louisa, are you here? Oh, Dylan, I'm sorry, your hand's up. Please, we'll get to Louisa in a minute. Yes, Dylan, go ahead.
This might be a dumb question, but this is only in respects to community property.
Yes,
and
only in Texas.
Correct.
Yes, this is property acquired while the couple's married.
Okay, I was just making sure.
Okay.
Thank you.
Yeah, Doug asked about survivorship. I'll get to survivorship in 1 minute. Mackenzie asked, what's the point of calling it a joint tenancy instead of just community property? Mackenzie, the reason why I call it a joint tenancy is that's how deeds are titled, right? If a husband and wife buy Blackacre in Texas, it'll be deeded as a joint tenancy. That's what it's called. So I just put the word quasi there in my own lectures to signify it's something a little bit different. Okay. So questions, right? The first characteristic of the quasi joint tenancy is that both spouses have to consent to the sale, right? One spouse cannot unilaterally sever the unities. Okay. All right, Louisa, are you here? Louisa, you here? No? Jayla, I think you're up next.
Okay.
So Jayla, let me ask you this question, please. In a regular, in a common law state, when you have a married couple that has a joint tenancy, what happens when the husband dies with a regular joint tenancy?
The remainder of the interest goes to the wife.
Right. What do we call that process you just described? What's that called? What's that phrase? Begins with an S.
Oh, why is it escaping me?
What do you call it when one spouse lives longer than the other one?
Survivorship rights.
That's it. There you go. You got it. Right. Survivorship rights. I had one of these in Conlo the other night. Thanks, Sheila. Where I was trying to get someone to use the word tears, right? Like T-I-E-R-S. And I said, what comes out of your eyes? And it's like, tears. And it's like, yeah, so you have to figure these things. So in a common law state, you have survivorship rights, right? But in Texas, there are no survivorship rights. I'll say it again. In Texas, with the quasi-joint tenancy, there are no survivorship rights. Instead, the husband's share of community property passes to the surviving spouse. What? Let me give you an example. What I just said will not make sense to you. Okay? Go to page 450 if you can. Who's next? Is that Marissa?
Yes, it's me.
Yeah, could you just want to read me the question on page 450, please?
H, married to W, saves $5,000 out of his earnings, which he deposits in a savings account in his name only. Subsequently, H withdraws the $5,000 and buys a lot, taking title in H and W as joint tenants. H then dies, dividing all his separate and community property to his son S, who owns the lot.
Okay, very good. All right, thank you so much. So let's just go this one step at a time, Marissa. Husband and wife are married, and he saves $5,000 out of his earnings. Okay? Is that $5,000 community property or separate property, Marissa?
It's community.
How do we know that?
Because he saved it while they were married.
Does it matter that he put it in his own banking account?
No.
Okay, it's irrelevant. Okay, then the question says the husband withdraws $5,000 and buys a lot. By the way, I'm looking at my monitor. That's why I'm looking away from you all. He withdraws $5,000 and buys a lot. Okay? And he takes title in husband and wife as joint tenants. So Marissa, let me ask you, is the lot community property or is the lot separate property?
separate community, perhaps.
You're giving me different answers here. What's the answer?
I know, I'm not gonna lie.
Well, what kind of money was used to buy the lot? How would you characterize the $5,000? You just said a minute ago.
Community property, so then the lot itself is also community property.
Exactly, right? When you buy a lot with community money, then the property itself becomes community property. All right, Marissa, one more question, right? The land is titled as husband and wife as joint tenants. What did I at least call a joint tenancy in a community property state? What's the phrase that I used?
A quasi joint tenancy.
Okay, very good. Thank you, Marissa. Okay. So we have here a quasi-joint tenancy. All right. Cassidy, are you here? I think I saw your chat earlier. Here, Cassidy?
Yeah, I'm here.
Okay. Oh boy, what's your background? What is that? Smurfs?
Just it's like a kind of an ethereal mushroom garden.
Okay, I'm tripping right now. And you're looking all translucent too, so this is very, very, very fitting.
I read for it.
Yeah, I like it. Okay, so it says here the husband dies and leaves all of his property, both separate and community, to his son. Cassidy, can the husband actually do that in Texas? And by the way, this question's in Texas, right? Can a husband leave all of his community property to his son? Is that even legit?
No.
No, you can't do that. So now comes the harder question. What can the husband leave to his son?
I was actually confused about this question.
That's okay.
See, I mean, I read that he can't actually leave anything to his son.
Zero. You think he leaves zero to his son?
Yeah, he can't leave anything to his son.
Okay. Well, Cassidy, first off, is there survivorship here? Does the wife get Blackacre by virtue of the husband dying?
Oh, there's no survivorship rights.
There is no Okay. So that's good. First, Cassie's correct. There is no survivorship rights because we're in Texas. If this was in New York, the wife would get everything, and there's no problem, right? But there's no survivorship. So then, Cassie, the follow-up question is: given that there's no survivorship, how is this property divvied up? How do we chop it up?
But because there's no survivorship, I mean, he still can't unilaterally convey that.
Well, he's not conveying it during life. He's with a tenancy by the entirety when there's a death.
Entirely when there's a death.
Yeah.
Then there'd be survivorship rights.
Right, but I'm sorry. Let me take you off spot so you're not on the gun with my internet not working.
It's okay.
I feel bad.
All right.
Let me explain how.
I don't know the answer.
That's okay, Cassidy. You're doing very well. Let me explain how this works. Okay. During life, the husband and wife have a unified interest, right?
Yes.
But upon death, it's no longer unified because there's no more marriage, right? In other words, once the husband dies, this community property thing kind of just goes away. Oh. And we actually say that the husband has a 50% share in the property and the wife has a 50% share in the property, right? But let me just give you the end answer. The wife now has 75%, and the son has 25%.
Okay.
Let me do that one more. Let me do.
So she has.
Hold on, chance. Hold on. Whoever's son, the wife has a claim to half of the house. Our infrastructure is not built for this, right? Okay, I'm gonna just. Okay, I'll try this one more time, and I apologize. This thing keeps bugging out. Okay. During marriage, they each have a unified share, 100%. But upon death, you effectively chop it up. The wife has a 50% share, and the husband has a 50% share. The husband is only allowed to leave in his will half of his property. The other half would go to the wife. So the wife ends up with a 75% cut, and the husband winds up, and the son winds up with a 25% cut. Right? The important part is, even though the will said the son gets everything, it's not enforceable. The son can only get, in this case, 25% of the community property. Separate property is fine. The husband can dispose of any inheritances however he wishes. If he inherited property, that doesn't matter. But of the community property, the wife gets 75%, and the son gets 25%. Right. Hold on. In torts, we had a little luck. We shut off our video and did only audio. Okay. Son gets half of the half. Right. Exactly. Yeah. 75%, 25%. Right. The wife gets her half and half of the husband's half. And the son gets half of the husband's half. I'm going to frequently just freeze.
I have a question.
Who is that? Is that Diana?
Yeah.
Please, go ahead.
Okay. So basically, the husband can't cheat the wife off of anything that is marital property, but he can dispose of any separate property however he pleases.
Yes, if it's separate property.
Because there's no survivorship.
Right, I'm sorry to interrupt the lag. If it's separate property, the husband can do whatever he wants with it. But for community property, he can only give it by will, basically a quarter of whatever there is. In other words, half of his half. Yeah, Cassidy writes, I don't mean to interrupt Anna, it basically acts like the elective share, right? In Texas, the quasi-joint tenancy operates like the elective share, where the wife can claim half of the husband's share. It operates in a very similar fashion. Go ahead, Diana.
Okay, so because there's no survivorship, right? Even if he dies intestate, that's how you say it, right?
That's right.
With no will, that's how you would get to the 75%, and he gets 25%, and then the rest just whatever.
Exactly.
Right?
That's exactly right.
Okay. Cool.
All right.
If he died intestate, wouldn't
hold on, no, guys. If you want to talk, raise your hand. We can't have this. All right. Just if you want to just raise your hand, then I'll put you off mute. Don't. If you put yourself mute, we'll be in a shouting match. All right, Chance, go ahead.
If the father died intestate, wouldn't the son get nothing? It would all go to the wife.
Well, in this case, he had a will.
No, but Diana's hypo said he was intestate.
Okay, so okay, I'm sorry. So go back to Diana's hypo. I'm sorry, Chance. I'll put you back on mute. If a father dies intestate, and let's say he has survived by a wife and the son, the wife would get basically half of his half. And if the son is the only other heir, he would get the quarter. Right? But generally, you have more than one heir. You have lots of heirs. So I was just trying to simplify it, but that's right. The wife, in other words, the wife gets what she's going to get regardless of the will. Right? In this case, the wife gets 75% with or without the will. It doesn't even matter. Okay? All right, I think Adam had his hand up a minute ago. If you want to raise your hand, I'll call on you. I'm sorry I have to do this stupid thing with calling on people because if you start talking over each other, it will get very messy. Yes, Michael, go ahead. I think you're still on mute, my friend.
Yeah, if there is more than one child, does the wife still get 75%?
Yeah, the wife gets her cut no matter what. Right.
The children just get the remaining.
They can fight over the scraps, right? They can divvy up the scraps. Exactly right. Other questions? Mackenzie had a question. Did I not answer it? I'm sorry. If he never took money from community property and they were joint tenants, the son will get 50%. So Mackenzie, to answer your question, in Texas, if a husband and wife own property as joint tenancy, even if they paid for it with separate property, I think it would still be considered a joint tenancy. It's really hard to have separate property in Texas if you're married. You can do it, but you have to have a special agreement. Okay. Other questions? Just click the raise hand button. I'd be happy to call on you. All right, everyone get that? It's a 75 for the wife, 25 for the son. All right, Nick, I see your hand. Go ahead.
Yeah, so just building on Mackenzie's question, in order to rebut the presumption that it would be community property, would you have to have both spouses affirmatively sign that it is a separate property?
Yeah, you would need a writing saying that they're separate, but also, to be frank, you need to actually manage it separately. That is, make clear that only one spouse is paying for the mortgage, one spouse is paying for the property taxes, one spouse is paying for utilities. It's even possible that you might have a writing at the beginning, and then 30 years later, it's clear that it's kind of owned jointly. That could nullify the writing. So it's very hard to keep things separate. You have to basically be perfect. You can't screw up. Thanks, Nick. Other questions? Anything else? All right, I'll move on. The next topic I want to talk about is managing community property. And the phrase manager is kind of like outdated because historically it was the husband, right? It was the husband who managed how the property was spent. But under modern law in all states, both the husband and the wife can dictate how property is distributed. Now, why does this matter? Gifts, presents. People always chuckle when we get to this part of the lecture. Your book gives an example of a famous, I think it was either a producer or an actor, I can't remember, but a guy named W.C. Fields. Oh, he's a movie star, that's right. I think he did some directing as well. And he was married, but he never got divorced. And he had lots of lady friends, as they call them. And he gave gifts to all of his lady friends without his wife's knowledge. And the gifts were a lot of money, almost $200,000. California had a unique law, and I don't think other states have this, but it's in California, where the wife can actually try to reclaim the money spent on the girlfriend presents. In other words, because the husband spent that money without consulting with the wife can sue the girlfriends, basically, and try and get the money back. This happened recently. You may remember a guy named Donald Sterling, and he was the owner of the Los Angeles Clippers before Steve Ballmer. He had to resign under very abrupt circumstances, but he had a lot of girlfriends, and he gave them very expensive presents. He gave them houses, Ferraris, Bentleys, Range Rovers, right? I mean, we're talking millions of dollars worth of gifts to these girlfriends. And his wife basically sued the girlfriend and sought recovery of the value. And the courts ruled in the wife's favor. So in other words, the girlfriends had to pay back the money. I guess it's sweet revenge of some sort. But this is still the law in California. I don't think you'll ever see this come up, but it's at least the law in California. Any questions on that? Garrett, yes, go ahead.
I actually have two questions.
Sure.
One, let's say I'm married and me and somebody acquire land and we're both joint tenants. Does my wife have a claim in my interest in the joint tenancy, or is it strictly, or is there a separation?
I'm sorry, did you acquire jointly? I'm not sure. Is the husband and the wife the joint tenants, or are you asking it differently?
Well, like, if, say, like, me and someone buy a tract of land and we're joint tenants.
Right.
Does my wife also get, since we're married, does she also have a stake in said property, or is it?
That would depend on whether separate property was used to buy the share, right? If community property is used to buy the interest, then it would be community property.
Okay. And my second question is just survivorship and joint tenants. Let's say the other person dies, I claim survivorship, And when I die, do my heirs get it, or does it revert back to the original person who sold it to us?
I'm sorry, say it one more time. I think I lost you in the middle.
For joint tenants, let's say the person who I'm sharing it with dies, and
Right.
so I get his interest through survivorship. And when I die, can I give it to my heirs, or does it revert back to the original seller?
Well, when you have a right of survivorship, you now own it in fee simple, so you can do whatever you want with it.
Okay, cool. Thank you.
Yeah. All right. Thanks, Garrett. Let's move on to the next topic. This one gets more complicated. What happens when you buy property on an installment, right? Let's say that you sign a 30-year installment contract. And let's say that the wife pays for, 10 years of it before she's married, and then 20 years after she's married. Right? This is a hard question. Is the property community or separate? And here there are two different rules. Texas has what's called the inception rule. Right? The inception rule. I put that in the chat. The inception rule. Or they also call, the inception of right rule. Okay, you see different ways. Inception of rule, the inception of right rule. What that rule means is property is characterized at the time it was acquired. So if the wife acquired the contract before she was married, it remains separate property. Right? So even if the husband pays for 20 years of the payments, the property is still determined as separate. Texas uses the inception of right rule. Other states use what's called the time of vesting rule. Right? Where you don't actually designate the title until all the installments are paid. And after the 30th payment was made, the 30 years of payments were made, it becomes community property. The Texas rule is a lot easier to apply. Right? You basically say, well, it was separate property at the outset, it remains separate property. The time of vesting rule means you have to wait around to see what happens. Right? Because what happens if a person's single, they get married, and they get divorced, and then they finish paying it off, right? So you have to wait to see what happens at the end. California uses what's called the pro rata apportionment. Pro rata apportionment. And this one's kind of complicated, complicated math. So let's just say, the wife spends 20% before marriage, and the husband and wife spend 80% after marriage. You would say that 20% of Blackacre is separate and 80% is community. It's kind of messy, but at least gives you a little bit more precision. So you have to know these three separate rules. In Texas, you have the inception rule. In California, you have the pro rata apportionment rule. And in the other community property states, you have the time of vesting rule. These rules are not going to apply in New York. Right? They're not going to apply in common law states because you can have separate interests. It's permissible. But in Texas, you have to have these sorts of rules. All right. Go to who's next? Heather, are you next?
Yeah, can you hear me?
Yep, loud and clear. Is that a puppy?
It is.
Hello. Okay, Heather, do you want to read for me, please, on page 452, problem number 1?
During marriage, H takes out a $50,000 life insurance policy on his life, paying premiums out of his earnings.
Okay, let me just stop you right there. Heather, when does a life insurance policy pay out? I know it sounds like a stupid question, but in general, yeah, that's right. A life insurance policy pays out when a person dies. Does a life insurance policy have any value during a person's life?
No.
Okay, that's right. All right, go on, please.
The named beneficiary is H's son, S.
Good.
At H's death, who is entitled to the $50,000?
Okay. So here's the rub. The husband, Heather, designated the son as a sole beneficiary, right?
Yes.
Can the son take all of it?
No.
Okay. What can the son take?
Half?
Half of what?
Half of the 50,000?
That's right. Why is that the correct answer?
Because the $50,000 life insurance policy would be community property, so the other half would go to the wife.
Okay, that's very good. So in this case, the wife is entitled to half, is $25,000, and the husband can dispose of the other half as he wishes to his son, which is $25,000. Now, Heather, just one more follow-up question. Why doesn't the wife get 75% here? Wasn't that what we said with the earlier question? You're right. But why does the wife not get 75%?
Because before there was an undivided interest in the whole, so she already had basically 50% and he had 50%.
Good.
In this case, it's just half of the
That's right.
50.
That's right. In this case, there is no present value. Thank you, Heather. In this case, there is no present value to the life insurance policy. So the wife doesn't have 50% to start with. The wife has 50% and the husband has 50%, and the husband can dispose of that 50% to his son as he wishes. The son gets $25,000. I see there's some questions in the chat. Do all the rest of the states have time of vesting rule? Yeah, you can look at it that way. It's actually, no, I think the other states would have the inception rule. They don't call it that, though, so it's hard to explain. But in other states, it's whatever people characterize it as. So it's based on how they how it's titled at its inception. I think it would actually be inception for the other ones. Sorry, that wasn't clear. I think the common law states like New York don't call it that, but I think it'll be more of an inception rule, if that makes sense. Okay. Next question, part 1B. Who's next? Allison, you here? Oh, Diana has her hand up. I'm sorry. Yes, Diana.
Sorry, I don't think I was clear with my question. I meant the rest of the community property states have.
Oh yeah, I'm sorry. Yeah, most of them have the time of vesting rule. That's right. I'm sorry. I didn't understand your question. I'm sorry.
Okay, thank you.
But we do have Allison. You here? Allison? Catherine, are you here?
Yes.
Okay, Catherine, so let me ask you the question. The next sentence says, suppose that husband had taken out the policy before marriage and that $3,000 in premiums been paid out before marriage and $7,000 were paid after marriage. How does that change the hypothetical? And let's just assume you're in Texas now, right? $3,000 was paid before marriage in premiums, and premium means the fees, and then $7,000 paid afterwards. How does that alter the analysis?
What?
How does that alter the question, right? What happens if you're in Texas?
Oh, so would she only be entitled to half of the $7,000 that had been paid after the marriage from the community funds?
How much is that?
$3,500.
And what does the son get?
The other $35.
Wait a minute. We're in Texas here, right? What rule does Texas apply? What's the name of the rule in Texas?
Inception of right.
And what does that rule state?
That whatever was originally put in, they're entitled to.
That's not exactly what I said. What is the inception of right rule? How does the book define it?
Whoever manages the community property is determined at the time that either spouse signs the contract of purchase and a separate property.
Okay, so was this policy taken up before or after the marriage, Catherine?
Before.
So how would we characterize the insurance policy? Is it community or separate?
Separate.
And can the husband leave his separate property to anyone he wants?
Yes.
So can the husband give all $50,000 to the son?
Yes.
But what about the $7,000 paid in after the wedding?
Oh, so he would only get after the wife's 3,500 has been subtracted.
Yes.
46,000.
Bingo. Perfect. Exactly. The wife would get 3,500, right? And the son will get the remainder, 46,500. Let me explain that one more time. In Texas, we use the inception rule. Whatever the property is characterized at the outset remains. So this policy was purchased before the wedding. Therefore, it remains separate property. And the husband can dispose of the separate property however he wants. But, and here's the big but, $7,000 of premiums were put in from the community property. The wife is entitled to a return of 7,000 divided by 2, which is 35. So the son will get almost all of it, 46,500, but the wife gets the remaining 3,500. So you can see how the Texas rule really makes a difference as long as you buy it beforehand. So if anyone has a spouse who had a policy before they were married, you might be out of luck. Chance asks, why wouldn't commingling entitle her to half? The reason why is that the insurance policy has no present value, right? The $50,000 only pays out upon death. All the wife can get is the half of the money put in from community proceeds. That's the reason why. Okay. All right, questions on that topic? No? All right, let's move on to the last topic of today, which is called migrating couples, which is actually a really significant problem. Generally, when you die, right? We all die. We're all going to die eventually, sooner rather than later, but we all die eventually. A person's estate will be determined based on where they live when they die, right? Your domicile matters. So if a person dies in New York, there are going to be common law rules that apply. If a person dies in Texas, there'll be community property rules that apply. But why is this complicated? Because some property can move, right? If you buy a horse, for example, the horse can actually move from New York to Texas. Some property cannot move. If you buy Blackacre, a piece of land, Blackacre cannot move. The issue of the migrating couple creates what's called choice of law problems. Choice of law. In other words, which law is going to apply? Right? So, one example, right? There's a husband and wife, and they live in New York. The wife earns $1,000 separately. She buys a horse. That horse belongs to the wife as separate property, regardless of where they move. Right? Because a property does not transmute. It doesn't change. Now, the same hypothetical. Husband and wife live in Texas. The wife earns $1,000. That money is presumptively community property. The horse remains community property. Let me make this point very clearly to you. Once property is characterized, its ownership does not change when the parties move. Again, once property is characterized, the characterization doesn't change when a party moves. It stays the same. Both parties can consent to transmute it, right? But it stays the same. Stuart asked, the law applies where they die or they're domiciled. Usually it's where they die where they're domiciled. I suppose someone could die in a plane crash overseas, but you still use your domicile to determine their property issues, right? You don't base the law of wherever their body happens to be. It's where their domicile is at the time of death, if that makes sense, right? Yeah, domicile at the time of death. Yes, Nancy. Nancy, go ahead.
Okay, so I'm confused. You're saying both that the domicile, the property issues are determined by where a person's domiciled when they die, but you're also saying that the character of the property never changes. So wherever that property was acquired, that's the law you applied there. You're just saying different property can have different
yes
couple?
Yes, exactly. Let me give you the next example I want to give you. The elective share, right? The elective share. This was the example I gave you at the start of class today. If a person dies in New York, they can seek an elective share. The spouse can seek an elective share. If a spouse dies in Texas, the other spouse cannot seek an elective share. So depending where you are means there are different laws that you have to seek. Tim? Go ahead.
I haven't really thought out my question, but can a husband and wife live in different states while they're married and then make it even more complicated?
Yeah. So the short answer, Tim, is yes. A husband and wife can live apart. There's a problem, though, with that, because there's a general idea of marriage that you're together. And if one spouse abandons the other, you get divorced for that. Now, if both parties agree to it, they can reach an agreement on anything. But in theory, if one spouse lives apart from the other spouse, they could seek a divorce on abandonment grounds. So it gets a little messy. So let me put you at ease. On the exam, I will have people living together who are married, and if they're not, I'll say it, but they'll be living together in the same state. Let's take a look at page 4, and I'm going to go a few minutes beyond 3:30. I apologize. Hopefully you can just stick around. If you go to page 454, there's a problem. I think, Dan, are you next?
Hi.
Hi.
Do you want me to just read it?
Yeah. Read for me, please, the question 454 about Ohio.
Okay. H and W marry and live in Ohio. From H's earnings during marriage, H accumulates personal property worth $500,000. Under Ohio law, W has at H's death an elective share of 1/2 of H's property. After retirement, H and W move to Texas, a community property state. H dies, leaving a will devising all his property to a daughter by a prior marriage. Texas does not have an elective share statute. What are W's rights?
And this is actually a Texas case from 1987. You could see. All right, Deanna. So let's walk through this one step at a time, right? The husband accumulates $500,000 in Ohio. And that's from the husband's earnings. Is that considered marital property or separate property in Ohio?
During the marriage, marital property.
Whoa, read it. It says H accumulates personal property with $500,000 from H's earnings. In Ohio, how would you characterize that $500,000?
Under Ohio law.
Ohio is a common law.
Ohio's not community property.
No.
So it's probably separate property.
That's right, Dana. The $500,000 is separate property. Now, Dana, what happens if the husband died in Ohio? What could the wife seek? Let's say the husband dies and he leaves his wife out of his will. He doesn't give his wife a penny. What could the wife seek?
Doesn't she have an option of elective share?
She can, right? The wife could seek an elective share, okay? But now we change hypothetical, Diana. The couple moves from Ohio to Texas. Does this couple have any community property?
think so because Texas follows the inception of right rule.
Well, no,
which means that
that's not relevant. No, we don't talk about inception of right here. That only deals with things where we're making installment payments, right? The question is actually more simpler, Diana. Does the $500,000 convert or transmute from separate to community when they move to Texas?
I don't think so.
So does this couple have any community property?
No.
So what does the wife get when she dies?
I want to say nothing, but
She gets zip.
that doesn't sound fair. But yeah.
No, you're exactly right. Can the wife seek an elective share in Texas?
No.
That's exactly right. In this example, my friends, the wife gets zero. The wife doesn't get a penny. She gets half of the community property. The community property is zero. Half of zero is zero. She gets nothing. So the entire estate, the 500,000, goes to the daughter from the prior marriage. Wife gets nothing. So this is why it matters if a couple moves from from Ohio to Texas. If a couple moves from Ohio to Texas, the wife gets nothing. If a couple moves from Texas to Ohio, the wife can then seek an elective share. So that's actually better. So it happens, a lot of people retire in Austin or whatever, right? And they don't update their paperwork, and the husband gets a little creative and decides to screw the wife over. It happens. So this is something that you should be aware of. But I will often test you on these issues of commuting couples, so make sure you understand this topic. All right. Yes, is that Dan again? Oh, here I am.
Okay.
Here I am.
Hi, Tim. Why are you big?
I'm sorry.
You want to take us?
I'm sorry. My I actually got kicked out of my own class. That's a new one for me. Deuces. Yeah, kicked me as well. I'm sorry, Dan. I want to ask you a question, and I'm really sorry I got cut out.
Yeah, I was just asking for purposes of the test, you expect us to know all 10 states that follow the community property.
I can make it easier. If you look at every exam I've ever given you, it was either California or Texas. So I'll give you one of those two states. You only have to know two. The only reason why is that, for example, if I give you California, you know it's the pro rata rule and not the inception rule. That's the only reason why.
Okay, and then would you just classify Ohio as common law?
Yes. Yeah.
Okay. All right. Thank you.
Hello, whoever's in the backdrop.
Sorry, that's my sister.
That's okay. All right. Other questions. I'll mention the common law marriage in a minute. But I'm sorry. I keep getting fair in my own class. All right. I'm almost done. I got like 1 minute left. Common law marriage. Several states, including Texas, have what's called common law marriage. What's a common law marriage? It's where a person, historically man and woman, but it can go either way now, just decide to hold themselves out as public as husband and wife. They don't need a marriage license. This used to make sense back in the day because people didn't go to court. They didn't go to government offices to get marriage licenses. About 10 states have common law marriages, including Texas. The reason why common law marriage is important is, in theory, in Texas, you can have a common law community property marriage, right? Where any property acquired during marriage of a common law nature becomes community property. So even if you never actually get married, you still have community property. And if you break apart a common law marriage, guess what? There's equitable division of assets. You can actually have a judge divvy up assets acquired during the common law marriage. This became an issue a lot with same-sex couples. For the longest time, they were not allowed to get married, but they lived together as if they were married. And the courts are asking, well, what if a gay couple lived together as if they were married? Is their property community? And can they then divvy up? Blake, you're raising your hand. You wanna speak?
I checked. Thanks, Jay.
I actually
Oy
checked
vey.
the laws here in Texas because I was curious about the common law marriage, and the addendum to include homosexual marriages here in Texas was not passed, so we're still excluded from common law marriage here.
Have the court? I know. There's been no statutory changes. Have the courts ruled on this issue? I looked into this about a year or two ago. There was no resolution. I haven't looked into it recently.
I checked the statutes on Lexis a couple months ago, and it showed that I can't remember if there was actual court ruling or if it was just that the amendment failed.
Yeah, I know there have been court cases because thank you, Blake and Jay. I'm going to ask. Let me just explain how this works. Let's say you had two guys who were in a relationship for many years, and they held themselves out as husband and wife, and then for whatever reason the relationship soured, and one of the guys said, "I want half of the community property," and the other guy said, "Well, we were never married." So it's this weird situation where you have a gay couple, one of them saying, "No, there was no gay marriage. We couldn't have that." The other saying, "Yes, we were married." So it's a sort of very strange situation where half the couple is denying the relationship, the other half is there. This happens in a lot of situations. People in relationship for 30, 40 years who insisted that they were, we're basically married, but we don't want to get paperwork done. And the second they break up, we were never married because they don't have to divide up the assets. You can actually have a common law prenup if that even makes sense. You can have basically an agreement in advance of how to distribute community property, even though you're never legally married. Okay, that's all I got. Anyone else want to add anything? All right, what I'll do is I'll end this room in a minute, and I'll sign back in about 2 minutes, and we can do office hours, if that works for everyone else. But I'm going to close this now, and I will be back in a couple minutes. All right, thank you all. I appreciate staying a little bit late today. Bye-bye. Thank you so much. Thank you. Thank you.